Fourteenth District Court for County of Washington, State of Michigan is now.
No.
All right. 14th District Court for County of Washington, State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge J. Cedric Simpson presides.
You may be seated. Mr. Ganatra.
Morning, Your Honor. My name is Kanat, Senior Assistant Prosecuting Attorney for the people. Your Honor, this kind of people move to waive any conflict between the federal court and the Office of Public Defender. Prosecutor's office does not believe a conflict exists, but if there is one present, we waive that for all the cases between prosecutor's office and public defender's office before the song.
Thank you. And who from the public defender's office?
Assistant Public Defender Hannah Apple, appearing on behalf of the Public Defender's Office. Your Honor, at this time, we do not believe that a conflict exists between the court and the Defender's Office. We believe any conflict.
Thank you. The court, for its part, also does not believe there's a conflict either with Michigan court rules or the cases decided thereunder. To the extent a conflict exists, given the waivers, the court will consent to hear the matter. Court does call the case People of the State of Michigan versus Andre Williams. See how, yep. He's on Zoom. Oh, NDO6. Thank you. Ms. Gaines, PD again, folks.
Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Williams. Ms. Gaines is stepping out. Thank you.
Court calls the case People versus Diane Spencer.
Oh,
Man.
Good morning, Your Honor. Tina Sachs on behalf of Diane Spencer. Ms. Spencer, please state your name for the court.
Diane Spencer.
Thank you. What are we doing?
Your Honor, Ms. Spencer wishes to waive her right to a preliminary exam and bind over.
Is that correct, Ms. Spencer?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor. I understand.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Ms. Saxon.
Thank you, Your Honor. Yeah, we waive the formal reading of the charge, stand mute on the charge.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
May 28th at 1:30 before Judge Conkey.
May 28th, 2024, 1:30.
Your Honor, is it possible to get another date or do I have to go to judge?
You'll have to do that downtown.
Okay, thank you.
Bond continued.
Thank you.
Yes, sir. Court calls the case, the People versus Kira Brown.
The people.
Assistant Public Defender Hannah Apple, appearing on behalf of Ms. Brown. Ms. Brown, will you please state your name for the record?
Kyra Brown.
This is a waiver also.
It is, Your Honor.
Ma'am, you're going to waive your right to have a preliminary examination?
Yes.
All right. You understand that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
We do.
Preliminary examination having been waived, defendants bound over on a single count. Ms. Apple.
Your Honor, we would acknowledge receipt of the information, waive its reading and absence, except for trial.
And your client standing mute.
Standing, yes.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
June 3rd at 1:30 before Judge Slay Monday.
third,
Yes.
June 3rd, 2024, 1:30, Judge Slay, Monday. Thank you. Son, continue. Court calls case People versus Carl Hearns. Good morning.
Good morning, and please, report Kareem Johnson, Fiddle Beyond Mr. Burns, approach to my right.
Your name, sir? All right. What are we doing on this?
Which had to matter several preliminary examination, also I just my client's file.
All discovery is complete.
Yes, Your Honor.
People would have their witnesses available. People have their witnesses available the 21st. Pardon?
Yes, we would.
Okay. Preliminary examination will be set May 21st, 2024, 9 a.m. That is before me. That's in person. As to bond.
I'd ask the court to set my client's file at $1,000 cash in return. This matter had been dismissed previously. Recharged based upon review of the evidence, no new information that should change anybody's opinion as to that. He does have another offense. There's a certain court will be addressing that matter about so asking $1,000, 10%, so he does still continue to improve that. Does that he will come back.
You win $1,000, 10% on capital case?
Yes, sir.
Okay.
If the court wants to go into further detail, he passed the polygraph. That's why the case was dismissed a few years ago. They brought the case back. None of this changed.
Response.
Your Honor, the defendant is also being held on another case which involves multiple counts of sexual conduct in the first degree, for which he can cash for sure. Bond is appropriate as that.
Where is that case?
That case is not judged.
Pardon?
That case is not judged.
Headed to trial.
Going to pretrial on the 29th, Your Honor.
Well, if it's going on the 29th, at this point, I'm not going to, I'll hear the preliminary examination and then I'll deal with bond, and that can be dealt with on the 21st. At this time, motion for bond reduction is denied. Bond will continue. Court calls the case People versus Dondra Washington.
Good morning, Your Honor.
Good morning, sir.
This is interview on John County, Mr. Washington. You don't see your honor.
They're not here.
I just leave a voicemail for them yesterday. That was they've been in contact with them previously. Surprising not here.
Bench warrant will issue for defendant's failure to appear. Bond will be set amount of 10,000 cash surety. That warrant will issue immediately. Thank you.
Judge. And do you need the AG to prepare and submit the bench warrant, Your Honor?
No, you guys are busy. We'll take care of it.
Thank you very much, Your Honor. Always a pleasure to see you, Judge. Thank you.
Good seeing you. Take care. Court does call the case People versus Alan Ascar.
Your Honor, I will then on behalf of the people seeking permission to practice pursuant to Michigan Corporal 8.120 under the supervision of Assistant Prosecuting Attorney Morgan Burrows.
Oh, is this your last day? Next Wednesday? Oh. Okay, I won't say bye. All right. Permission to practice is granted.
Assistant Public Defender Hannah Apple hearing on behalf of Mr. Escar. Mr. Escar, we state your name for the record.
Alan Ascar.
Thank you.
Your Honor, we are asking for a brief adjournment of 1 week and to address bond in this matter.
1 week. Is he held on anything else?
This is the
All right.
The other, we are simply asking for a 10% option as to the bond that is already set. Mr. Ascar is working 6+ hours a week. He's a sole provider for his child, does have a residence here in Washington County. All of his family is local, and his most recent criminal history is nothing of an assaultive nature. And it's from 2022. So we asked for just a 10% option to bond today. And Your Honor, I do believe he has pulled out of Huron for 8,010%. Your Honor, that has a 10% option and a traffic related matter.
Mr. Bond.
Your Honor, people object. In this case, the victim and defendant were named accused of a child in common. The victim was at the apartment to see their child and was in front of the back. The defendant came in and he verbally aggressed the victim. She tried to leave with a letter. She had to jump out of the second-story window with their child to escape. And after the police came, he was found with the gun that she had reported missing earlier. Be very concerned for the safety and welfare of their child. Your Honor, Mr. Ascar denies those allegations. The firearm was not located on him. That's the reason for the adjournment, is that we need to have some further investigation regarding that, but we are simply asking for still a cash component with a 10% option.
Motion for bond reductions tonight. I'll leave the bond where it is. I'll set this out 1 week to the 16th. And after you look at it, then maybe I'll address it again, but maybe not. At this point, bond will continue. Court calls case People versus Ayad Abelis. Should have done that. Yeah.
Your Honor, I'm sorry. This is in Miss Gaines' case.
This is Miss Gaines' case. Okay. Does anybody know where Miss Gaines is?
Well, we are working on trying to find her anyhow.
Really? You've lost Miss Gaines.
It's a GPS code.
Sir, I'm just gonna ask you to have a seat. As soon as they locate their missing attorney, I'll call it out. Court calls case People versus Vasquez Davis. Try to butter me up. I'm doing fine, thank you, Ms. Wayne. I know.
My name is Vasquez Rayshawn Davis. Middle name Rayshawn, last name Davis, first name Vasquez.
Yeah, I got it. All right, what are we doing?
I believe that we're asking for the adjournment so that you have to. Yes, we're asking for an adjournment, right?
How much time did you need?
A few minutes. Well, 3 weeks.
3 weeks out. May 30th, 2024, 9 a.m.
Thank you.
Thank you. Bond continue. Somebody from the PD's office is gonna have to deal with the in custody. If you can't find, oh, it's about time you show up. I'm gonna do that. Emily. Court does recall the case, People versus Andre Williams.
Hey, Mr. Knappman.
Good morning, Your Honor. Director. Your Honor, I contacted the Adler where Mr. Williams was placed at this time. They indicated that they were not able to make a visitation available for today's date. Visitations are Monday. I didn't get this assignment until Friday. So they're Mondays and they're Friday evenings and the weekend. So I was not able to schedule to meet with you for today. I did contact Mr. Sinatra, and I would ask for a short adjournment. He and I can speak.
All right. Mr. Williams, can you state your name, please?
Joe Williams.
Thank you, sir. Adjourn this to May 23rd, 2024, 9 a.m. Bond continued. Thank you, Mr. Williams. Court calls the case People versus Joshua Akins. Somebody over there. Nice pants.
I look more green on that. Andrew, so there's green on the people. Green on that. I'm sorry. Attorney Hannah.
Really? I know she's there, but really under her supervision? Yeah. Permission to practice is granted.
Your Honor, today's date and time set for a probable cause conference. Mr. Akins is signing a preliminary examination. He does wish to waive this preliminary exam.
Is that correct, sir? You.
Your Honor, upon his waiver, the people have agreed not to add a habitual. That's correct, Your Honor.
All right. Sir, you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 and 3 following. You have the floor.
Yes, sir. That's the information we waive its reading, standing.
Defendant never waived from a reading, standing mute to all 3 counts. Court will enter a not guilty plea. Pretrial will be set for
17th at 1:30 before Judge Slay Monday.
June 17, 2023, 24, excuse me, 1:30. Said Slay Monday.
Yeah.
Slay Monday. Bond will continue. Thank you. Court calls case of People versus James Jones.
Mr. Knappman, on behalf of the people.
Morning, Your Honor. David Michael, City Attorney on behalf of the government.
Okay. What are we doing?
Your Honor, 2 things up this morning. One is the PCC and the other is additional. Prejudice for the issue of bond. I don't know which order you prefer to do that.
Whichever.
Your Honor, my client was arraigned, bond was set,
He was ordered as part of the conditions to test corrections. When we appeared last week for the probable cause conference, the court remanded the defendant because he had not been tested. We explained to the court that he had two issues. One is that he is basically homeless, does not have good, reliable transportation, which made it difficult for him to get to community corrections. And the other is that he just has some health issues, probably the more significant is he doesn't have transportation. We've said it for today, give us an opportunity to address you again on the issue of bond. With regard to the PCC, I have discussed these matters. I was going to be asking for a couple of weeks because I told the court last Thursday, he does have an issue, a matter out of Wayne County. We were going to try to get him arranged between last Thursday and today, but because it's raining, we couldn't do that. Wayne County always being as accommodating as they are, we're not doing this. So that's where we're at.
All right. Response from the people.
Your Honor, I'll leave the bond reduction question. Court's discretion, main issue, of course, is testing. If he believes, we want to make sure that he's following the court's orders and community correction.
He just said to me, Your Honor, he will test.
Yeah, I will test. You know, I have to admit that I'm a chronic COPD person now. And some mornings I feel good, I can get up and I can move. Some mornings I can get up, I can't move.
Okay, I understand that, but you got a test.
I said, I'll test. It's time for me to test, I won't be there.
Okay, because if you're not,
I understand.
you know what's going to happen.
I understand. This won't happen no more. Thank you. We'll test.
I'll reinstate his previous bond in this matter. As to the PCC, what do you want me to do?
Your Honor, we're asking you to be adjourned until the 6th of June. One of two things is going to happen today. Either he's going to be released by the jail here and Wayne County will come pick him up. If he is released to the street, then I will take him to Wayne County and get him arraigned. And get the discovery in that matter, so Mr. Gannett and I can discuss these cases.
Probable cause June 6, 2024, 9 a.m. You're gonna need Ann. Come here. I'm gonna need new orders on this.
Okay.
The new community corrections orders.
I'll make sure you get that.
We gotta check on this.
I don't believe so. But we have the other one.
It's good. They put it on the other thing. Yeah. Court calls case People versus Iliad Abeles. She took it out. Never mind. I'll pass it. Court calls case People versus Casey Atkins.
Yes, sir, I am here. I don't know where Miss Gaines is.
Is this Miss Gaines too?
Yes, and sir, I'm in the hospital.
You're in the hospital?
Yeah, they're sending some information over as we speak, because I've just recently found out that I have to be transferred to U of M for a skull base tumor.
What are we doing in this?
And I have not talked to Miss Gaines. I have talked to the public defender's office several times, and the information
Okay.
is being
All
sent.
right. Okay, we got you. Hold on a moment.
Okay.
pass over.
All right.
That's correct, they're off. Communication with the staff. I did just learn that she is going to be transferred to another hospital very shortly.
Probable cause conference, May 30th, 2024, 9 a.m. Bound continue. Thank you. Court calls case People versus Christopher Nyker.
David, I will see the hearing on behalf of the defendant.
Your name, sir? All right, what are we doing?
Your Honor, I know you're going to ask if discovery is complete. I want to compliment Ms. Barossa. Between last Tuesday and today, not only did she get me all the videos, but she got me videos that I can actually look at. So we are prepared to for examination.
Shouldn't have complimented her. She'll get a big head. Anyway. Would the people have their witnesses available the 21st?
Your Honor, I'm not available. You go to 28th.
I have no objection to that.
Preliminary examination will be set in person, May 28th, 2024, 9 a.m. before Judge Barr. Bond will continue. Thank you. Persons, yeah, but not on.
They're.
What do you mean? Yeah. Are they, yeah, have they brought them up yet?
Oh.
Probably not. Court calls the case People versus Nicole Bacon.
This evening, the record.
Okay.
Your Honor, we are asking for an additional adjournment here. There's some discovery that I still need to get secure and also find.
May 23rd, 2024, 9 a.m. Bond continued. Court calls the case People versus Sean Carlson.
No, it's warrant here about Mr. Carlson.
John Carlson.
Thank you.
Your Honor, this is a probable cause conference. We are negotiating with the people. Mr. Carlson has began attending parenting classes. He's anticipates he'll complete those in the next 2 weeks and get proof. So I'm asking for an adjournment so that we can provide that to people in hopes of result.
Probable cause conference, May 30th, 2024, 9 a.m. Bound continued. Thank you. Court calls case People versus Scott Penner.
Okay, senior assistant. Representing the state.
Your name, sir?
Scott Penner.
All right, what are we doing?
Your Honor, I believe in that discussion with this, we talked about if the Army would allow us to approach.
Yes. Record should reflect we had a bench conference in this case. Probable cause conference will be moved out 1 week to the 16th, 2024, 9 a.m. Bond continued. Thank you. Court calls case People versus Michael Clopton.
Morning, Your Honor. Fellow attorney, assistant public defender on behalf of Mr. Todd.
That's none of that. That's not Clapton.
Maybe I did speak to him in the hallway earlier. Maybe.
And what happened? Where is he? Come on, Otatella. Okay.
Perhaps we get through my bond argument at the bench rather than last.
Oh, we're gonna have a bond argument. Where is he?
He heard that I have a bond argument.
Well, let's wait for him to show back up. I'm gonna pass it. Court calls case People versus Seth Cope.
Mr. Canard.
Senator, I'm with on behalf of Mr. Seth Hope, who appears via Zoom. Seth, please state your name for the record, please.
Seth Cope.
Your Honor, I put a waiver form in file.
He's waiving on both cases.
Yes.
Is that correct, Mr. Cope?
Yeah.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all 6 counts in 2 cases.
Thank you, Your Honor. We acknowledge that information. Waive his formal reading. Standing.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea to all counts. Pretrial in this matter will be set
July 10th at 1:30 before Judge Conlon.
July 10th, 2024, 1:30, Judge Conley.
Thank you.
Bound continued. Yeah, as soon as I can.
Thank you.
You said 10th, correct?
Yes.
Thank you. I got that. It's fine. Court calls the case People versus Jacob Dillian.
Your Honor, we're just asking for 1 week adjournment here. He's being considered for drug treatment for, that's my understanding, that we just need to get a better read as to whether or not he'll be accepted.
Are they gonna be able to do that in a week?
Yes, Your Honor, that's my understanding.
We're waiting, but I suggested we adjourn to get APA Bonnie's input. She's away this week, so I heard the email.
Probable cause conference, May 16th, 2024, 9 a.m. Bound continued.
Thank you, Your Honor.
Court calls case People versus David Copeland.
For the on behalf of people. Simply but and decided why they have to be a problem. Very in keeping with the theory of these hearing with the funds. I called Mr. Copeland and he was here. I would have.
Yeah, That'll happen. Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety. That warrant will issue immediately. Thank you. Court calls the case People versus Eddie Gardner.
And Mr. Sinatra for the people.
Great.
Morning, Your Honor. Christina Constantino, appearing with an Gardner. My right.
Good morning.
And I am appearing on behalf of Mr. Gardner on case number ending in 0656.
Twin Games Senior Assistant.
Your name, sir?
Eddie Gardner.
Thank you.
And Your Honor, it's, at this time, we are asking for an adjournment of the probable cause conference. I was just assigned the case, I believe, yesterday. And so obviously we need an opportunity to review discovery, ensure that we have all this, et cetera, prior to setting appointments.
Now we've asked for the adjournment of two cases today.
Probable cause conference in this matter will be adjourned May 23rd, 2024, 9 a.m.
Mr. Gardner has one request. He would listen to he indicates that he recently had, that he has been on parole, that he waived his parole hearing, and that if the parole board may consider him being able to go to the Department of Corrections, if Your Honor would indicate as on the
Form to send him to the Department of Corrections, and then that's not going to happen. He's here. We'll hear these matters. We'll dispose of these matters, and then he can go. Bond will continue. Thank you. Court calls case People versus LaShawn Covington.
And is that on behalf of people?
When Your Honor, Assistant Public Defender was television on behalf of Mr. Covington. Yes, sir.
Morning, Your Honor. Sean Covington.
Thank you. What are we doing?
Your Honor, we would ask for the hearing on this matter for discovery.
And Your Honor, I wish the attorney would like to respond.
Go ahead.
Your Honor, at this time, the people will be requesting the defense bond be modified to the original 100,000 cash surety tax agreement. This defendant failed to appear in 2023 week of this case and exam and proper witness. He was also out on probation for had stopped and picked up 2 felony charges, I believe. And I believe in this case, he was released on May 7th, and it showed on, actually still has a warrant for a BOP, other non-support warrants. And the people believe that in this case, the bond would be appropriate at 100,000 given the serious nature and concern for the victim's safety. In this case, the victim and defendant the defendant was at the residence with their daughter. The victim picked her up. The argument began while they were arguing. The defendant pulled the gun from his waist, cocked the gun as if to load around, pointed it at the victim and also at their car that their child was in. The victim was in fear for her life, and he struck her with the gun 3 times and then fled. When the officers talked to the victim, she had noticeable swelling above her left temple, a cut above her ear, and blood on her shirt. These were also concerned given the defendant's past history of assaultive and domestic violence charges, as well as dismissed domestic violence. So maybe asking the bond set at 100,000.
Response.
Your Honor,
How did he come into custody?
Your Honor, I was in Detroit.
Okay. How'd you get into custody? Did you walk in or were you picked up?
I was picked up in Detroit.
Mr. Allen.
A case out there. And then I handled all the case. I came out here. I got discharged off of conviction. I have to stay in Washington County for about 7 years. So when this came in,
Your Honor, he was picked up originally, but I think that this second bond, attempt at bond increase, is second bite at the apple. He was released. He's coming to court today. He's ready to.
But hold it, while he was out, basically absconding on this case, my understanding is he picked up other cases?
That's the people's understanding. While he was on probation for aggravated stalking, the judge slates court.
Those are support cases, if I'm correct. Good.
Or it might be on 14. But Arnold said that he had a VOP hearing on 5/2, the judge said.
The initial was a failure to appear when we were before the thing. I did that arrangement for him. And there were 2 months of time where he was in the hospital, if I recall, and he suffered some burns as the court made clear.
Hold on a second, because back, just looking for a date on this, I don't know that he, the defendant just didn't come into court. He was incarcerated in Wayne County, January of this year. And then proceeded to send us information for a plea by mail. Requesting a trial date, review of bond with a request for dismissal due to the hearsay clause, and Washtenaw County has no jurisdiction over me. Because he's a permanent resident of Wayne County. Yeah, go ahead.
At the arraignment, we were going back and forth with our magistrate Pink and I, and she said, I won't quote her exactly, but the summary of it was, let him out on bond because some of it was confusion. He should be holding himself to the same standard as an attorney, but this was kind of an attempt at self-representation that went horribly wrong. And so as you can see, he's here now with an attorney. He's coming into court to address these charges, to address everything that's happening. He's not a flight risk judge. He's here now, so I would say that.
He's not a flight risk? Where was he?
He was in the hospital for 2 months, Your Honor.
When?
The court date in question, I remember it was April 4th, and he was in the hospital at that time.
Now, your assistant prosecuting attorney, Morgan Barroso, and I have the people looking back at our notes. What we see is that this is a 2022 case. He was set for exam pro se on March 7th. The victim was present, willing, and cooperative. The defendant appeared on Zoom. The court, they tried to proceed with the exam at that date, but the defendant had insurmountable technical difficulties, so it was adjourned out to April 4th. And on April 4th, the defendant didn't show up.
Did not
show up. He failed to appear, and he was put in bench warrant status. After that, on the 11th of April 11th of 2024, over a year later, he's in custody in Wayne County and mails in the misdemeanor plea by mail to the court.
Correct.
So he's in bench warrant status for over a year. And obviously there's something else, other context with law enforcement going on because he's in custody in Wayne County during that time while in bench warrant status. I'm sympathetic to him being in the hospital for a couple of months in there, but that doesn't explain the other 10 months plus where he was in bench warrant status and failed to return himself in. at this point, I think that there's an issue with his bond being where it is and with him being out of custody, at least without having a GPS.
Well, but he didn't appear for preliminary examination.
Correct.
This, my lawyer informed me that I have a case in Washington County for a different reason. So at that same time, my lawyer told me to call down here, get on video camera. I was doing everything on video camera from the hospital. I saw you one time on the camera. So
It wasn't my preliminary examination.
because I was in the hospital, so the technical reason for the computer stuff.
Oh, no. So then, after you missed the preliminary examination, what took you so long to turn yourself in? Well, you didn't turn yourself in, you got picked up.
It's like Magistrate Garwood says that all the time. I tell this to my clients. I said, look, if your cell phone bill goes out, if cable goes out, you're gonna pick up the phone, you're gonna call that and get that resolved immediately. And
I don't know if quoting Magistrate Garwood is convincing to me.
but what I'm saying is, Your Honor, I explained this to him. He wasn't represented before. He didn't understand. He tried to represent himself.
Oh, I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months. And I don't know why a bond was set when we finally get to him in the amount that it's set at. In my opinion, that's a clear abuse of discretion. He didn't appear for 2 court proceedings. Well, appeared at 1. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
It was a obstruction of justice, and I took care of that case. I came back here, I got dismissed off of probation. Judge Smith, bear with me because I lost my lyrics, I lost my whole day. So I had to get my body together. And then I'll promise her I'll come back and take care of this because I need to do this time. But I lost my whole day, as you can see. So I learn how to read and talk.
I understand that. I'm glad it's worked for you. All I'm saying is you haven't appeared at these proceedings. You didn't turn yourself in. You got picked up. And that's the only reason that you're here. Otherwise, we would probably not be seeing you. As I've said, I think it's an abuse of discretion that this bond was set as it was. Your bond now will be $50,000 cash surety, defendant's remanded. Oh. Did I send it to you? I did not. I'll set the probable cause out. I'll just set it out since I took him into custody. I'll set it out next week, May 16th, 2024, 9 a.m. Court does call the case People versus Yusuf Cyrus. Who is this? Who? Far out? I'll hear it. Hang on. Bring it back. Yeah. Step back a second, sir. I'm sorry. Court does call the case of People versus Mohammed Farah.
People. Good morning, Your Honor. On behalf of Mr. Farah, now you matter.
Okay, what are we doing?
Examination.
Discovery is complete.
Yes. We would all do that.
Of course you would. Discovery is complete. People had their witnesses available the 21st. Preliminary examination will be set May 21st, 2024, 9 a.m. That is before Judge Valvo. As to bond.
Thank you. Regarding bond, Mr. Farah does have another matter. Your malicious bond is $2,625. He tells me that he intends that they will that he's granted. PR on this case.
Did he post it?
Nobody does intend to if the court is inclined to grant him a personal bond in this matter. He does have.
So we get into a chicken or the egg, because I'm not moving it if he's got another bond.
And other cases of CCW use.
Thank you.
That's correct, Your Honor. Would this be more appropriate to raise a preliminary examination after he posted the bond in the other matters?
I would think so. Judge Valvo would be more than happy to hear it.
Thank you.
At this time, motion for bond reductions denied. Bond will continue. Thank you. Clerk recalls the case Peter versus Yusuf Cyrus.
Entertain on John, yeah, Cyrus who appears. Taking it directly.
Thank you.
Your Honor, we're just asking for a 3-week adjournment to submit mitigation information to that here at the row, so consider it.
May 30th, 2024, 9 a.m. without objection. Bond continued. Thank you. Court calls the case People versus David Davis.
Mr. Canatra for the people.
Good morning, I'm Judge Water, this is public defender on behalf of Mr. Davis. Approaching. Mr. Davis, would you state your name for the record? Davis.
What are we doing?
We worked out a plea agreement. Plea form was sent to the court last night.
A plea form that indicates he's going to plead to attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 are dismissed. That's the court's entire understanding of the agreement.
Correct. Yes, sir.
7-1.
You sound too much part of testimony about the truth and all this, and that's what the truth tells God.
Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $2,000, I think it's actually $1,000 fine plus court cost. You understand that? All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in 14A2 District Court. All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead?
Yes.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. And because you believe that you are indeed guilty of this offense? On the date of February 29, 2024, at the location of Buckingham Drive near Hamlet Drive, Superior Township, Washtenaw County, State of Michigan, did you come into contact with Washtenaw County Sheriff deputies? What happened?
I was in the garage, I didn't tell you to come out to the garage, and I was waiting for you.
How'd that work? Yeah. You kind of came out of the garage. Yeah. You have no dispute they were giving you a lawful command to come out of the garage, do you? You're not disputing that it was a lawful command they were giving you to come out of the garage. You just didn't come out. Well, not. But you eventually came out. Yeah. Counsel, I complied with the court rule. Would it be proper to accept this defendant's plea?
Defense is satisfied, thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be when? July 9th, 2024. What time? Doesn't matter. 10 a.m. Before Judge Barr. Bond continue.
Thank you, Your Honor.
60 days. It's 2 months. Okay. Emily, I'm just counting. I don't know.
Yes.
Court calls case People versus Wayne Franklin.
Attorney Morgan Rose on behalf of people.
Your name, sir. Thank you. What are we doing?
I'm going to set this matter for preliminary examination. I would ask the court also to consider a bond.
Discovery complete on both cases. People have their witnesses available the 21st. Preliminary examination will be set in person, May 21st, 2024, 9 a.m. before Judge Valvo. As to bond.
Your Honor, it's my understanding that the complaining witness of this matter is likely left the state. She does not reside with my client. He has his own place that he'd be staying at. My client has 2 jobs. He works for a cleaning service called Arrow Cleaning, where he works nights. He also works at AF John, where he's a property manager for various strip malls. He indicated he resides on Alpine Drive. His mother also lives locally. He has her support. I'd ask the court to consider releasing Mr. Franklin personal recognizance bonds. We have to comply with the tele requirements the court felt that if they were necessary. The allegations in these cases are not particularly aggravating. There's been, to my knowledge, no indication that he's had any contact with the complaining witness since he's been incarcerated. So I would ask if the court would be willing to consider his release today. He has reported to me that he is the only provider for his family. His wife does not work, and if he continues to be incarcerated, he will lose his both of his jobs.
Respond.
I first want to note out the gate that he has bond denied out of 15th District Court, and that is not up until May 15th. But on the attempted home invasion case between April 7th and April 11th, the defendant assaulted and stole the victim's iPhone. The defendant was released on a PR bond on April 19th. It was prohibited from having contact with the victim or going to the residence. On April 24th, he told the victim that he was allowed to have visitation with the children and came to the residence. The victim, after that, then called the court and learned that what the defendant told her was a lie. The defendant has repeatedly harassed and texted and called the victim, resulting in aggravated stalking charges in the case 24 F55094. In the attempted home invasion, he violated the no contact order, founded on the defendant's work, or founded on the victim's work, causing damage to the security. And it was so loud that it caused neighbors to take notice and filmed the defendant leaving the scene. I also want to note that as far as his contact with the victim, he did text her, he contacted her multiple times, resulting in aggravated stalking charges. But one of note, which gave us concern, is on April 26th, saying, I don't know if I can ever forgive you. God is going to really have to help me through this time. He violated a no contact order, lied to the victim about what he was allowed to do, and appeared at her residence in violation of no contact. So it wasn't even just virtual or verbal violations. At this point, I would object. I also want to note that we had requested $100,000 on each of these files. On the attempted home invasion, we were only given a $5,000 bond, and on the aggravated stalking, we were only given a $15,000 bond. I'm not asking for an increase today, but I do think any reduction in those already small nominal bonds would be inappropriate at this time.
The text message that was cited by the state is the only alleged contact that he had that makes up the stalking that's a violation of any kind of bond condition. As far as the home invasion is concerned, The only allegation that suggests that he was even involved is the statement of the complaining witness. The alleged damage to the door, according to the report, indicates that the deadbolt was not broken, but the chain was. So the only way that he could have done that would have been to bend the door so far in that it broke the chain, but the deadbolt held. There's no damage to the door, which doesn't actually make any sense.
Motion for bond reduction denied.
Thank you.
Court calls the case People versus Michael DeBella.
Mr. Canatra, for the people.
What's he doing outside?
Sorry, on behalf of Mr. Cabela. So. We're here for a plea today. I submitted the advice of right hand.
The form that I have before me is that he's going to plead to attempted resisting and obstructing the 1-year offense. On his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
7 more. Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. I do believe we're $1,000 fine plus court costs. You understand that, sir?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. Still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any questions regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Anybody promise you anything other than what's been stated here today on the record? Anybody threaten you or coerce you? Doing this voluntarily? Of your own free will? And because you believe that you're guilty of this offense? January 22nd, 2024, at the location of Westmoreland and North Wallace in the city of Ypsilanti, Washtenaw County, state of Michigan, did you come into contact with a police officer on that day?
In my rear view, yes, it was 3 blocks from my truck.
Yes.
What happened?
What happened? Horrible error of judgment, Your Honor. Lions euphoria. Just horrible. Yeah, I was close to home. Thought I could get home. Big terrible error. Yeah, police were behind me, and
Did they turn on their lights?
at one point, yes, Your Honor. And then
Did you stop?
I did not stop.
Did you know that they were giving you a lawful command to pull your vehicle over?
At one point, yes, Your Honor, and then they turned the lights on.
So you're saying you didn't resist them?
I did.
Hey, you know what, counsel? You're going to talk to your client. I'm not taking this plea if he wants to play around and give excuses for everything. I'm done. I'll call it back up. You talk to him. Court calls the case People versus Clement Gill.
Prosecuting attorney Morgan Barossa, but after the vote.
This is both under document. On behalf of Mr. Field stands for.
What are we doing?
Requesting determined in order for particular logical exam here requesting to be conducted after discuss this matter with Mr. Smith Burrow, so he can get the chief.
That is correct.
You prepared this order, counsel?
Yes, Your Honor.
Next time, if it's going to be a stipulation, both parties need to sign it.
Yes, Your Honor.
How much time is it going to take to accomplish that?
Your Honor, it's currently scheduled for the 14th.
Probable cause conference will be adjourned then to May 30th, 2024, 9 a.m. Bond continued. Or calls case people versus Mary Barney.
Then now we have this people.
Wow. Wow, wow, wow. Wow, wow, wow. Go ahead. I'm sorry. I was just floored.
Under the supervision of Senior Assistant Public Defender Joy Gaines on behalf of his party.
Wow. So just a question. How do you feel coming from that side?
Strange.
Yeah, I bet. Well, welcome back. It's good to see you. You're doing well, I hope.
Yes, I am. Thank you.
Permission to practice is granted. Go ahead.
And Your Honor, we would be asking for an adjournment for additional discussion with the prosecutor.
You come all the way up here, make my day, and then you ask for an adjournment. Dane sent you up to do that, didn't she? All right, how much time are you going to need? Thank you. I heard. Probable cause conference, May 23rd, 2024, 9 a.m. Bond continued. Thank you. Court calls the case, People versus Jordan Earl.
Morning, Your Honor. Assistant Public Defender Adam Miller, on behalf of Jordan Earl. Mr. Earl, can you say anything?
Jordan.
Thank you.
Your Honor, we are reviewing my client's right to examination.
Sir, is that correct? All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following. Your turn.
We acknowledge receipt of information, Your Honor. Waive formal reading and standing at this time.
Defendant every way formal reading standing mute. Court will enter a not guilty plea as to all charges. Pretrial will be set for
July 10th at 1:30, Judge Conlon.
July 10th, 2024, 1:30, Judge Conlon. Bond in this matter with its conditions will continue. All right. Thank you. Court calls case People versus Zachariah Aruska Dennis.
Assistant Public Defender on behalf of the
You're waiving.
Yes, yes.
Sir, you're waiving your right to a preliminary examination? All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with count 3 following.
Your Honor, defense would acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading standing mute. Court will enter a not guilty plea. Pretrial will be set for
May 20th at 1:30 before Judge Slade Monday.
May 20th, 2024, 1:30, Slay Monday.
Thank you.
Bond continued. Thank you. Court calls the case People versus Wayne Eagles. Or Eccles. Thank you.
Today's been kind of a probable cause conference. We received and reviewed all of the discovery, we began negotiations with people. I'm asking for an adjournment to continue negotiations.
That objection, probable cause, May 23rd, 2024, 9 a.m. Bond continued. Court calls the case People versus Shantez Evans.
Since the prosecuting attorney working for us on behalf of the people. At the son of one, we have talked at them.
Okay, what are we doing?
And we wish to bring up the second.
You signed a waiver for him? I do have it, okay. Sir, is that a correct statement? You're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it? You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor, thank you.
Preliminary examination having been waived, defendants bound over on count 1 with 2 and 3 following. Ms. White.
As to your argument. Stand you to wait for reading of the information is there.
And then having waived for reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial will be set for
July 10th at 1:30 before Judge Conlon.
July 10, 2024, 1:30, Judge Conlon. Bond continues with its conditions. Thank you.
I'm not sure.
It's what? What about it? It's about to die? Did you charge it?
Yes, I thought I was charging them when I was sleeping, but when I came in, they said charge.
Okay, and you're telling me why I don't have a charger?
I don't know, but I was just like.
You were letting me know in case something happens?
Yeah.
So that we don't run out and grab you when it dies?
You want to have a record, right?
Oh, is that what this is? This is a record? Seems like premeditation to committing an offense. Go and get it charged. All right? Sit there and look at it. Make sure it's charging. All right? That's okay. I'm going to let Judge Conlon know. Or since yeah, I'm going to let him know. His tether probably died. What? Bless you. All right, young man, take care. Court calls the case People versus Vincent Lambert. Is that your mom? Your grandmother? She told you to say that, didn't she? No. Yeah, I'm sure they did. Young man, if your charger's having a problem, since you're down here, stop over at Community Corrections. Don't want that thing to die on you, okay? Thank you.
Your Honor, Alex Warren, we have a Lambert.
Sir, state your name.
Vincent Lambert.
All right, what are we doing?
Your Honor, today's date comes up for a probable cause conference. I think first order of business of Mr. Lambert does wish to apologize to the court. I understand he comes to this court at his last probable cause.
Oh, yeah, he was.
Also, with Mr. Lambert, I think he's expressed regret for his actions and wishes to apologize to the court.
Yes, Your Honor, Mr. Simpson, I would love to apologize to you mostly for being judge disrespectful, you're basically in your home, so hopefully you can accept my apology.
Right. I accept his apology, but I'm not purging the contempt. He'll do the 30 days.
Understood, Your Honor. You would ask the court to adjourn this probable cause conference to the same date as the other two matters. We're hoping to eventually get all three matters to the circuit court.
Set that for the 6th. All right. I think that was right. Do you remember?
Yeah, September 6th.
6. Probable cause conference will be adjourned June 6, 2024. 9 a.m. on continued. Thank you.
Thank you, Your Honor.